Hello, my name's Katie Tank and I'm an attorney for NeighborImpact, and I'm going to be speaking to you today about HIPAA and FERPA, describing what they are and why they're important to you as an employee for NeighborImpact. I'm going to start with HIPAA. HIPAA is an acronym for the Health Insurance Portability and Accountability Act that was passed by Congress back in 1996. HIPAA did a number of things, but most importantly for you as a NeighborImpact employee is it included the HIPAA privacy rule, and this rule requires the protection and confidential handling of what we call protected health information, or PHI. NeighborImpact has access to PHI, and you may encounter that during your employment with NeighborImpact, so it's important for you to know the privacy rules and when and if you can share that information with others around you. So the HIPAA privacy regulations require covered entities to ensure the confidentiality and security of protected health information when it is either transferred, received, handled, or shared. And this applies to any form of PHI, whether you're sending it via email, whether you're sending it over a fax, whether you're discussing it verbally, or on paper. Any transmission of PHI is protected under the HIPAA privacy rules. And the privacy rules also say that you can only share that PHI with those who absolutely need to know. So I want to talk a little bit about what is protected health information. It is all individually identifiable health information that's either transmitted or received by NeighborImpact. And as I mentioned, the privacy rule calls this protected health information, PHI. And there's some components of that. I'm going to go through that for you now. Individually identifiable health information is any information, including demographic data, that relates to one, an individual's past, present, or future physical or mental health or condition, the provision of healthcare services to an individual, or the past, present, or future payment for the provision of healthcare to the individual. And on top of that, with that information, there's something that identifies the individual that is associated with that information or provides enough information for you to determine that it is that particular individual. For example, a social security number, an address, or potentially a name or date of birth of that individual. And an example of PHI that would be protected is John Smith, our client, suffers from Alzheimer's. That is protected health information because it identifies that he suffers from a medical condition, and we've identified him by name. Similarly, if we said our client who lives at 222 Elm Street suffers from Alzheimer's, that is also protected PHI because we can figure out from the address who that individual is. And so that is also considered protected health information. And a violation occurs when you share that type of information, that protected health information, with people who do not need to know in the organization. So if it is PHI, you need to obtain the written consent of the client before you release that information. And if you fail to get that written consent, then that is considered a violation of the HIPAA privacy rules, and there are certain criminal and civil consequences that flow from that I'm going to get into. You can disclose that information for treatment purposes, but obviously NeighborImpact doesn't provide healthcare treatment. And so if you come into access of PHI, in most situations that disclosure is going to require the written consent of the person who it belongs to. So if there is a breach, the HIPAA rules require that, one, we notify the individual who's been affected. If it impacts a large group of people, 500 or more, we also have to notify the media. And also for any breach, we need to notify the Health and Human Services Secretary. And so it's important to, if you become aware of a breach, to let your supervisor know so we can trigger all the notification requirements that are required under HIPAA. If there has been a violation, the Office of Civil Rights or the OCR may impose a penalty on the covered entity for failure to comply. These civil penalties are fairly significant. They run from $100,000 to $50,000 per violation, up to a maximum of $1.5 million per year, and they go up from that in the event it's willful or there's multiple violations. So these penalties are very severe, and they can dramatically impact neighbor impact. On top of that, there's potential criminal liability if you knowingly or intentionally disclose PHI, and that includes a minimum of 1 year in prison and a $50,000 fine. So it's important for you to know the rules and be aware of them. And if you ever have any questions about whether this is protected health information and whether you can disclose it, I encourage you to talk to your supervisor or manager first and get their advice on that, just to be safe anytime you're dealing with what you might consider to be personal health information. I'm going to talk now briefly about FERPA. What's FERPA? A lot of acronyms today. That's the Family Educational Rights and Privacy Act, and that's a federal law designed to protect the privacy of student educational records. And this law applies to all entities that receive funds or grants from the Department of Education, and obviously NeighborImpact does receive federal funds for its Head Start program, so it is subject to the FERPA laws. And FERPA gives both students and parents basic rights with respect to their education records. One, they have the right to control disclosure of their education record. Two, they have the right to review their education records upon request. They also have the right to request an amendment of inaccurate information or misleading portions of their education record. And finally, they have a right to file a complaint regarding noncompliance with the Family Policy Compliance Office of the U.S. Department of Education. Under FERPA, like under HIPAA, schools must have written permission from the parent or the eligible student before they can release any type of information from the student's records. Under FERPA, schools can release that information under very limited circumstances, but for the most part, what you need to know is if you get a request for a release of student records, that you know that it's protected under FERPA, and we need to take certain steps before we do that, generally, to get that parent or eligible student's written authorization before we do this. If a student or parent feels violated, they can go to the U.S. Department of Education, and the consequence would be that if a violation were found, NeighborImpact could lose its federal funding for Head Start and other grant funds. And so the consequences are severe, and so it's important to know and be aware of the rules. There's also other confidentiality laws that apply, rights of privacy, that go beyond FERPA and HIPAA, that can protect any private information regarding an individual, and it's important for you to be aware of that. An example of that would be the fact that individual is a client of NeighborImpact or even receiving services from NeighborImpact, or the types of services. That's the kind of private information that should not be disclosed outside the organization or to individuals who don't really have a right or a need to know. So a lot of legalese. What does this really mean for you on a day-to-day basis? One, obtain written consent before you disclose any protected information, both PHI or student records. Limit disclosure of that type of information to those who absolutely need to know. Be careful who you include in communications, and don't forward that information to those that don't need to know. For example, if you receive private information in an email, you wouldn't want to distribute or forward that email to someone in the chain who really has no need or right to know that information. So be careful who's CC'd on those communications, and be careful when you're transmitting that information, particularly over email. Keep files or documents containing protected information segregated under lock and key, generally particularly the student records that we've talked about and the protected health information. Don't leave those kind of documents in public view. Don't leave them in your office. Cover them up. Don't leave them sitting on a fax machine. Don't leave them open up on your screen, on your computer screen. Be very careful to protect that information. Don't use email to discuss or disclose protected health information unless that email is encrypted. If you're faxing that kind of information, send it only to a confidential fax, and likewise, if you're receiving it, make sure that you also are receiving it on a confidential fax and that you're there to receive it and it's not sitting on the machine exposed to anybody who may come up and want to use the machine or who walks by. You also want to, when you no longer need that protected information, it should be shredded. In fact, the law requires it. So rather than putting it in the recycle bin or throwing that information in the trash, that information should be shredded so it can't be accessed by unauthorized people. It's also important not to share this kind of information with coworkers or friends or family. You may be concerned about an individual and want to, in a compassionate way, share that information, maybe about a coworker who has a condition or maybe a child in Head Start who you're concerned about, and we appreciate the concern, but please do not share that information, again, with people who need to know, because good faith is typically not a defense under these laws. Also, don't ask staff or board members about information that may be protected if you don't have a legitimate need or right to know. You may be curious, but know the rules. You don't want to be sucked into that, and so please don't ask or require people to share that information with you. And certainly if you do hear it and you shouldn't have heard it, then don't pass it on to other people who also don't have a need to know. Also, beware of auditory privacy issues. Don't be discussing these types of matters in the supermarket because you don't know who may hear, or similarly in a break room or lunchroom. If you are talking about protected health information or information from student records, do it in the privacy of your office with the door closed, again with those people who have a need to know that particular information. And then finally, most importantly, don't disclose the name of NeighborImpact's clients to people outside the organization or those who don't have a need to know, and don't disclose the types of services we're providing to that individual, as well as that is considered private information. Finally, I want to close with what happens if you get a request from a parent or an outside agency or anybody for release of protected health information or student records or information that you consider private. Many of those, as we discussed, many of those records can't be lawfully produced, and they should not be released to a third party. You should immediately contact your supervisor if you get that request. For example, if perhaps you're served with a subpoena, pass that information on to your supervisor and they will handle it. But under no circumstances should you, without the permission of your manager or supervisor, be disclosing that information to outside or third parties. So hopefully this information has been helpful for you. If you have any questions, again, I encourage you to talk to your supervisor and manager to get their thoughts on this topic, and so to ensure that both you and NeighborImpact are legally compliant. Thank you.